The terms litigation funder and litigation financier are used interchangeably and describe an entity that has its own pool of capital set aside to invest in litigation. There are two primary ways that a funder can access the money, including withdrawing from a dedicated investment fund or raising capital through syndication from their network of sources. Damages in ERISA, Employee Retirement Income Security Act, suits are paid directly to the plan, not to individuals, which is why using a litigation financier is less common in these type of complaints. An individual using typical litigation funding can't turn around and pay back the company who provided the capital. ERISA does permit payment of a substantial attorney's fees for an individual. Payment to a financier for a class action suit has not been fully established. A litigation financier will usually require an upfront non-disclosure agreement (NDA), which makes tracking the use of this type of funding difficult. Only after the NDA is signed will a financing company typically begin its due diligence on the client and the case. This has been used as a delay tactic in multiple cases. Upon completion of its research, the finance representative will present the information to an investment committee for approval and release of funds. U.S. District Court for the Eastern District of New York held in Benitez v. Lopez that litigation finance agreements are not relevant to litigation and should not be discoverable. That a person has received litigation funding does not assist the fact finder in determining whether or not the witness is telling the truth. In the long run, litigation financing is a growing field and frees up a firm's capital for other investments and priorities.